The books of account shall show a true and fair view of the transactions, of course, prepared on the double entry principle, following the accrual system. They shall be maintained at the registered office or any other place that the board of directors have decided, giving an intimation to the registrar. And they shall be, or they may be, maintained on the electronic system in the soft copy, subject to the rules provided by the company's accounts of companies rules. This is where we had stopped. So these were the initial aspects of the books of account: true and fair, double entry, accrual system, registered office, electronic form. Moving on to the other subsections of section 128 which provide for books of account. The next aspect is inspection. Can the books of account be inspected by any person other than company officials? For what purpose? When? Inspection of books of account is a major aspect. Now the inspection of books of account is provided for in a manner where the inspection is permitted. That is, the books of account of any company may be carried out by the board of directors at any time. Naturally, they are the people who are maintaining the books of account. So books of account may be inspected by the board of directors at any time. They may be inspected by the registrar or any other statutory authority if necessary. For example, section 240, inspection, inquiry, investigation, where an inspection is warranted by the registrar. Where an inspection is warranted by the registrar or any statutory authority like the Enforcement Directorate, Income Tax Department, the GST Department, this can be done. The registrar or any statutory authority may inspect books of account provided the company is intimated sufficiently in advance. So if it is intimated, they can go at the appointed hour and inspect the books of account. Who is the third? It is you, the auditors. The auditors may inspect books of account at any time during working hours. So the board of directors can inspect the books of account at any time. A statutory authority, including the registrar of companies, may inspect it by giving advance intimation to the company, and the auditors may inspect it during working hours. Now there's a new provision which has been inserted about the inspection of books of account of the subsidiary. The books of account of the subsidiary may be inspected by the holding company through any of its directors appointed for the purpose through a resolution passed at a board meeting. Every word is important. So now you have a new provision relating to the books of a subsidiary which may be inspected by the holding company through any of its directors picked for the purpose through a resolution passed at a board meeting. So now comes the fourth party or the fourth agency which is eligible or has the right to inspect books of account. This is exclusively between a subsidiary and its parent, a subsidiary and the holding company. It's a new provision. Otherwise, the board of directors of a company do not have access to the books of account of any other company. Now, remember, there is a provision also that wherever the term subsidiary is used in the Companies Act, the term subsidiary shall include an associate. So subsidiaries and associates are dealt with on the same footing with respect to powers or duties of the parent, the holding company, through almost all provisions of the Companies Act. So this is also provided for by section 128, allowing for access to inspection. Now the question that arises is, what about the members of the company? Can the members of a company inspect books of account? You will say, why not? They are the owners of the company. They have a right to access, they have a right to know. But then, I would like to use this provision to introduce something very important about an Indian statute. If you can understand this one principle with respect to Indian law, most of your complications or difficulties automatically evaporate. Remember, this is a thumb rule, this is a fundamental principle that anything specifically prohibited, if it is listed in a provision, only that is prohibited. Therefore, anything else is permitted. Putting it differently, from the point of view of an advocate, unless anything is specifically prohibited under an act, it is implied permission. Similarly, the vice versa. Unless something is specifically permitted, it is implied prohibition. Let me use a principle here. I have allowed for an access to inspection by the board of directors, statutory authority, including registrar, auditors, and the holding company's board of directors. Now, if I were to ask you a question based on this, can the members of a company inspect its books of account? The answer is, by implication, no. Because they are specifically not permitted. What is that? That means a lot of things. It means that these four which are permitted to inspect books of account of a company are not a list of examples that is exhaustive. These and only these can inspect the books of account of a company. So by implication, the members of a company shall not inspect the books of account of a company. Very strange. Members or shareholders are the owners of the company. Now the legal perspective is this, that members cannot inspect books of account in the absence of a specific permission to do so. So I apply that principle of a law here. It's a very, very important thumb rule of any statute. Unless specifically prohibited, it is permitted. Unless specifically permitted, an action is prohibited. Besides, look at the practical difficulty. I can't allow 1,000, 2,000, 10,000 lakh members of a public company to inspect books of account of a company. What will happen to the books of account if they inspect? And there's a provision coming up later that the books of account of a company must be maintained for a period of 8 years at least. If the government prescribes a longer period, it has to be preserved for that longer period. Practical difficulty number one. Practical difficulty number two. The shareholders or members of a company inspecting books of account will understand nothing. What is the point in allowing access to inspection when you can't understand it? No. Two. The third aspect. Why do you need to inspect books of account when the financial statements as audited by 3 professionals are sent to you 21 days before the AGM. Financial statements are made out of the books of account. Financial statements are a condensed form. It's a reflection of the books of account. Then what is the point in allowing an access to inspection of books of account? So books of account must be maintained neatly in safe custody for a period of at least 8 years. So it becomes practically difficult to allow it. So we conclude saying that the members of a company, the shareholders of a company, cannot inspect the books of account. However, I don't prohibit the Constitution to add an empowering provision. The articles of the company may permit members to inspect books of account. If the articles says that, then there is nothing about a specific prohibition or a specific permission. All that is set to rest. So the articles of a company may allow access to inspect books of account by the members of the company. So that is about its inspection, the inspection of books of account. So as a package we have covered truth and fairness, double entry, accrual system, registered office or any other place as decided by the board of directors, soft form and inspection.